terms of restoring the public confidence, what do you think it takes beyond, obviously there's an effort beyond the hearings themselves. One reason that you're here today, you said, was that.
Yeah.
What do you think it's going to take to begin to change people's attitudes?
I don't know. What do you think it's going to take?
Time.
Yeah.
Maybe more transparency. Is there any thought about, is it antiquated to have closed juvenile hearings? I'm wondering what the initial reasoning was behind that, and if there's consideration about, well, maybe we need to rethink the way we operate.
Yeah, that's an interesting question, and that's one of the details that Mr. Connor, I thought maybe we might come back to, was just some of the more specific kinds of questions. The whole, going back historically, to 1900, when juvenile courts were created in Chicago, these were the original problem-solving courts. We talk about problem-solving courts as though this is some great new concept, but the original problem-solving courts are, what do we do with these juveniles on the streets of Chicago, and how do we handle these kids? And the idea was, okay, only the court system can really make the system accountable, the social services for kids, but we want to protect these kids and assure their privacy. Now, over 100 years, that has evolved, and what were the problems of street urchins in Chicago are significantly more different than the problems juvenile courts are handling today. So, so we have to think about this idea of public access. My inclination is oriented toward public access. I got to be a judge by accident. I wanted to be a newspaper reporter, and I know that it evokes some smiles, but my third year in law school, I was able to get a clerkship, but I couldn't get a job as a newspaper reporter, which goes, I'm not sure what that tells you about me, but in any event, my inclination is always toward public access. So I think access to juvenile cases does a great deal to give us insights into abuse of power by a judge. And for that purpose, it's very important. But at what cost to the child? And that's the balance. And the current system is now, if you're 14 and a felony, it's an open hearing. You can go, and even down to 12, depending on the crime. Whether that's the right balance, I don't know. That's one of the things that we have to talk about. But we can't lose sight of the fact that, although we want to control judges, we also want to protect kids somehow too. And how that works, how we do that, I'm not sure.